Alrighty, so good afternoon, everybody, and welcome to 5 Steps to Avoid Leaving a Mess for Your Family with Adam Diamond. My name is Kristen Mertz, and I'm the Communications and Engagement Specialist here at Elderwerks. Just a reminder, this event is being recorded and it will be posted to our Facebook and our YouTube post-presentation. Elderworks is a not-for-profit 501c3 organization, and our mission is to provide seniors and their families with information, referrals, and guidance for senior living, home care, and support services to help make appropriate decisions. The guidance we provide helps seniors stay home well or transition successfully into a new senior living opportunity. We provide education on a variety of aging topics for consumers and professionals who work with seniors. Please add any questions into the chat box and we will answer them at the end of the presentation. And with that, I will go ahead and turn it over to Adam. Thank you all for being here today.
Hello, everybody. Thank you for attending. And first and foremost, I'd love to thank the Elderworks crew for the opportunity to present this information. So as you can tell from the screen and the introduction, we're talking about 5 steps to avoid leaving a legal mess for your family when you're either incapacitated or not around. And the first thing I want to explain is who am I and why the heck do you care about what I have to say? So my name's attorney Adam Diamond. I'm a second generation estate planning and real estate attorney. I'm with Diamond Legal. We have offices in McHenry and Lake Zurich. I've been practicing for 20 plus years, so hopefully one of these days I'll get it right. And but I also have the privilege of working with my dad, as you can see in the diamond picture here. He's been practicing for 40 plus years. His predecessors, John Lewis and Harry Kinney, also did wills, trust, and estate planning. So during my career, I've had the privilege of working with a lot of families when things happen, and I've had the privilege of seeing the preparation and the result. So a lot of what I'm going to be talking about today is very practical in nature, because what I found is most of what I'm doing now is what's called probate avoidance, which is just setting things up so that they're properly in place to avoid having to go to court for stuff. And a lot of the ways to do that are tied to the legal stuff, but more practical in nature. So let's dive in a little bit. The first step in avoiding a legal mess is having powers of attorney. Well, what's a power of attorney? In its simplest form, a power of attorney is a legal document, and Illinois has very specific requirements for how to sign them, write everything, that gives someone else the power to do something for you. Generally speaking, Illinois has 2 different basic powers of attorney. There is a power of attorney for property, which deals with all things financial and real estate, digital things like email, so property, so to speak. And then there's also a separate medical power of attorney that deals with medical decisions. So a lot of people will come in and say, oh, I have a power of attorney. And I say, which one? And they go, what do you mean? I went to the hospital, I filled out a medical power of attorney, and we're good. Well, you're missing all of these other accounts, and it would be beneficial to have both. So sometimes people have one and they don't realize that there's another one. Kind of related to this, there's something in Illinois called a living will, which is a document that documents your wishes when it comes to tough situations, end of life type of things, terminal illness, and things like that. So in Illinois, the power of attorney for medical and the living will cross-reference each other. So they're designed to be used hand in hand. So there's a lot of confusion about that. So if you don't have any powers of attorney, then in order for someone else to manage things for you, even your spouse, unless it's a joint account, they need to go to court. So these legal documents can be very powerful and practical. And for most people, having a basic set of powers of attorneys is a great way to avoid leaving a mess if incapacity comes up. A lot of times, family members will come in with mom or dad. They're having a hard time remembering things, and it depends on how far that condition has progressed to determine whether or not they have the legal ability to sign those documents. So with a power of attorney, Sooner rather than later is always the general rule, because if someone has dementia or is in memory care and they're is not legally able to make their own decisions, they're not going to be able to sign a power of attorney. So that's the first way. The second way is to direct your assets. No, not like a movie director, but make sure your stuff ends up where you want it to by making sure it has a home. Well, what do you mean, Adam? Well, there are 4 different ways that things travel in Illinois when someone passes away. The first is what's called joint ownership. And most people are kind of familiar with this, either with bank accounts or real estate. If someone's on the title of your house with you or your bank account with you, an and account, if someone passes away, it goes to the other. So that's joint ownership, and that's a very handy way of passing things on when you're not around. Note of caution here. A lot of seniors or parents that have adult children say, well, I want my child to be able to write checks for me and be able to access my accounts and manage them, so they make them a joint owner. In most cases, that's not a good approach, because when you make someone a joint owner, the good news is they can have survivorship. So if you pass away, they get it. The bad news is you just gift to them an immediate gift. And so if the value is more than, I think $18,000, there could be a gift tax issue. Whereas if someone inherits it upon your passing as a beneficiary, which I'll talk about in a minute, then if your total estate is less than 4 million, there is no tax. Plus, if you make someone a joint owner and they go through a divorce, they get sued, they have to file bankruptcy, they get into a car accident, that's half their asset. And so we've had a lot of messes with parents adding their kids to the bank account for convenience. What you really want to do is add them as a power of attorney or a signer of convenience. So that's the best way to approach that. So joint ownership is the first way of making sure things go to where you want when you're not around. The second, I kind of alluded to, and most people are familiar with, is what's called a beneficiary designation. What does that mean? There's different terms that banks or financial institutions will use: payable on death, beneficiary. They're all the same thing. When the people that own the account are no longer around, who gets it? This can be a person, it can be people, individuals, or it can be entities like a corporation, LLC, or a trust, which I'll talk about in a minute as well. Beneficiary designations are very powerful in Illinois. If you have a bank account or an investment account, retirement account, which I'll talk more about in a minute, that has a beneficiary on it, if you pass and they're alive and meet the criteria, that's it. They get it. So beneficiaries can be very powerful, and we have some beneficiary designations we can use for real estate now that we didn't used to have. Over the last 15 years or so, we now have what's called a transfer on death instrument that you can record on your home or real estate that acts a lot like a beneficiary designation. It automatically goes to those people and you avoid probate. So first, joint ownership. Second, beneficiary. Third is a will, your voice from the grave. You have a will that says what happens to your stuff when you're not around, then that can dictate where it goes. The key thing to remember, though, is to enforce a will, you need to go to probate court. The exception to this is if the value of everything without a home, without a beneficiary, that doesn't go any other way, is less than $100,000, then your executor can run around with your will, and if they're willing to sign what's called a small estates affidavit, which says, I promise I'll make sure all your bills are paid, and then they can take care of things using the will in your plan. So a will is the third way that you can dictate where your stuff goes. And the fourth, near and dear to my heart and most estate planning attorneys, is of course a trust, like a VIP club for your assets. So think of a trust like a suitcase. You create the suitcase when you're alive, and the most commonly used suitcase for probate avoidance is what's called a revocable living trust. What does that mean? The suitcase is open. You can change it when you're alive. You can do whatever the heck you want with your stuff. You still own it. It doesn't have its own existence. until you pass away. Once you pass away, then I say the suitcase closes and your successor suitcase holder or trustee legally picks up the suitcase and follows your rules. It's automatic, it's private, and that's why if you want plan B and C and you just don't want things to automatically go to people, you want to be able to adjust or get more specific, a revocable living trust is a great tool. Now, of note here is if you have more specific concerns about things like asset protection, Medicaid planning, and things like that, there are other types of trusts called irrevocable trusts that can be used for that. Those can be complicated, and I highly recommend talking to an attorney about those. But the basic concept is I give these things away while I'm alive so that I can't get them back, and then I can legally and ethically claim they're not mine. So if you give everything away and it's irrevocable, then that can be configured for different types of asset protection or Medicaid planning. Or special needs trust can kind of act like that as well. So trust, like a VIP club for your assets, that's the fourth way. And so when I talk about trust, that warrants tapping my brakes here to our special little snowflake, which are retirement accounts. There's a ton of confusion about retirement accounts and whether or not they can be put into a trust or they should just be left out through beneficiaries. My general rule is if the family has a financial planner or an accountant with a strong opinion, I'll work with them to make the legal strategy match it. Because some trusts can be configured like a conduit where the retirement funds are supposed to just pass through. And some argue that there's less tax issues with that. Others say, nope, don't put a retirement account in a trust, leave it out. There's all sorts, that's a murky area. So if you run into confusion with that, then I would say start with the tax advice and then tag in the lawyer to make sure, or use a lawyer that does both. Next, step 3, have a will. A will can function as your backup plan because I said to enforce it, you got to go to court. So if you are planning on having beneficiaries on everything and something gets accidentally left out, then the will can be used to make sure that goes to who you want. Everyone has an automatic estate plan created by the state. The fancy legal term is intestate succession. And for some people, it makes sense, and for some people, it doesn't. For example, the standard plan for the state of Illinois when you pass away is half of your stuff that doesn't have a beneficiary or isn't joint or isn't in a trust. Half that goes to your spouse and half goes to your kids in equal shares. Well, wait a minute. If I'm the only one that owns my house and I pass, half goes to my spouse and half goes to my kids, that could be a mess. Exactly. So if you want to have a different plan than the state's plan, you can create and properly sign a will that documents your wishes and make sure they're followed. So the will is a backup plan. It's also, from a practical matter, really handy for your executor to run around and take care of small things. In Illinois, if the total value of an estate or things that are left out, meaning don't have a beneficiary, not in a trust, or don't automatically go anywhere, is less than $100,000, then that's considered a small estate, and your executor can run around with a will and fill out what's called a small estates affidavit and take care of small things, cars, small bank accounts, and things like that. So the third step is to have a will that documents and protects your wishes, the backup plan. The fourth step is a magic list. Wait a minute, Adam. That's not a lawyer thing. Nope, that's a practical thing. If you have a list somewhere that someone can find that has account descriptions, account numbers, approximate values, and big pro tip here, who the beneficiaries are on the account, life insurance, retirement accounts, who are the important contacts that keep the trains running on time. Having an organized list of these things somewhere where people can find it is one of the biggest things that delivers the peace of mind people want when they're thinking about this stuff. Well, why? Well, like I said, I've been doing this for 20 years and I have family members come in when unfortunate things happen. And a lot of times they will bring in a folder, a beautiful folder of legal documents, accompanied by a jewel bag or a box of stuff from the person's desk, because they're trying to figure out what they have, where it goes, and how it gets there. And even if they have a trust, they're trying to figure out what's in, what's out, what was actually done. So creating a magic list and periodically updating it. And this can be digital, although I would also have an analog version or a way to access it, is a really powerful way to make sure that your family can find stuff and who knows what. There's another practical tip here. When if someone passes away and they have a retirement account or a financial account, a lot of times the company can't talk to anybody but the beneficiary. Well, wait a minute. What if you don't know who that is? Well, then your family gets to play financial or account roulette here, and everybody calls and sees if the company will talk to them, because that means they're beneficiary. This can be very frustrating. This can be very tedious. And the other thing is sometimes there isn't even a beneficiary and we have to go to probate to straighten it out. So having a clear list that everyone can follow is a huge tip to make sure you don't leave a mess. Step 5, the diamond binder or dead book. Have a parking spot for important things like passwords, who you talk to for medical stuff. Here are some examples of some good do-it-yourself planners. There's a classy one called the Peace of Mind Planner. You can pick these up on Amazon for 15, 20 bucks, or funny ones, I'm dead now what? So I give these out as gifts. People jokingly call it the Diamond Dead Book. But these are really good organizers for all of the non-legal details that someone would need to do to figure out who to call and where to go for information. My stepbrother passed away a couple of years ago unexpectedly, and he was single and kind of private. And we couldn't get into his computer or his phone or anything. And I realized that having an analog strategy, either a binder, like with all of our plans, we give you a 3-ring binder and a parking spot for this stuff, and then one of these books where you can write stuff down, so that however you organize, you can create a list that people can follow. So that's step 5. And believe it or not, if you follow those 5 simple steps, you're going to be way ahead of most. Most people come to see me and they have absolutely nothing in place. So these steps will help you avoid a huge mess. So that is my prepared presentation. And so now I'd like to open it up for questions. Great question. Before meeting with you, what should we gather? Well, I can't speak for every estate planning attorney, but I can speak for myself, and this is a good general rule. So the first thing we're trying to figure out is, what do you need? And so in order for an attorney to figure out what legal tools will help you avoid a mess or make sure things go where you want them to, we need to know a little bit about your family and a little bit about your assets. So the general rule in Illinois is that if the total value of everything, including life insurance, retirement accounts, I mean everything, is less than $4 million, then there isn't a tax for the privilege of passing away. And so that's one type of plan. If you're between $4 and $8 million worth of assets, then there's a different type of plan, frequently with 2 trusts that we can use to make sure that we avoid any unnecessary estate taxes. So a list of assets, approximate values, and the type of assets. Is it a bank account? Is it a retirement account? Some estate planning attorneys get into the tax aspects of retirement accounts and whether or not to put them in or out of trust or how to have them travel. Is it a stock, bond, things like that? What is it? Because you can have a beneficiary on all sorts of things like bank accounts and investment accounts, but there are some special snowflakes like real estate, where you have to do something different, individual stocks, cryptocurrency. Not a lot of people have that still, but that's a special little snowflake and how it travels. So a list of major assets and what they are is really helpful for your estate planning attorney. The next thing is, who do you want your power people to be? What do I mean by that? Well, we talked about powers of attorney, and most estate planning attorneys, by the way, will give you a questionnaire or a flyer. And so if anyone wants one, I'm happy to give you mine so you can see, even if you're not meeting with me, you're meeting with another attorney. So we want to know about your family, and then who you want to be your powers of attorney, or who you want to be in charge of stuff if you're incapacitated or not around. So having that basic information can be a huge help for meeting with your attorney. So, all right, now everybody woke up. Okay, so let's see what else. Okay, what should we gather? Which holds beneficiary listed in retirement account or the trust that has beneficiaries listed? That is a great question. So if you have beneficiaries listed, it goes. So if you have a trust and the asset is not in the trust, or the trust is not the beneficiary, that is not in the trust. So which holds beneficiary listed in retirement account or the trust that has beneficiaries listed, the direct beneficiaries who it goes to, unless the account is already in a trust, but then it wouldn't have a beneficiary. So if the retirement account is in the trust, it shouldn't have a beneficiary because the trust is configured already for that, unless the trust doesn't have a beneficiary. There are very specialized trusts that some financial institutions do that may not have that, but generally speaking, if you have an account in a trust, it won't have beneficiaries. The trust rules will govern. What are the various types of powers of attorney? We have the power of attorney for property, which is all things real estate, personal, financial property. The power of attorney we use includes digital documents as well. So that's physical, financial, or real estate things. And then there's a power of attorney for healthcare that is all things health related. There's a few additional documents a lot of estate planning attorneys do, a living will to document your wishes. I like to add an extra HIPAA authorization in case there's confusion and things like that. But those are the two basic powers of attorney. What do I do if I'm an only child with no siblings? So talk to an attorney. No. If you're talking about, it depends on what you're talking about when you're an only child. If you're talking about what your parents can do, or if you don't, or whether or not you're trying to talk about giving things to your kids. But if you're talking about your parents to you as an only child, it depends on what their wishes are if you're not around and whether or not you have any kids. Some parents with one child and no siblings will just have them as a beneficiary and everything. And if the beneficiary or the child isn't around, well, they don't care. And so that's one approach. Or they could get more specific, plan A, B, and C, either with a will or a trust. Good question. If your loved ones is deemed cognitively impaired and should not make decisions, do you have to amend the power of attorney or make the other POA, letter from MD? Unfortunately, okay, so if you have a power of attorney and you are impaired and unable to legally make your own decisions, you will not have the legal ability to amend or change that power of attorney. So if you want to revoke it, probably the easiest way, or revoke or modifying who can make decisions for you, you're probably going to need to go to court for a legal guardianship and have it straightened out that way. So I've approached my husband several times, but his comment is, my wife will get everything. I don't want to get jinxed. My wife will get half of everything, followed by the comment, I don't want to get jinxed. So when I talked about the default plan of the state, the fancy legal term is intestate succession. The general rule is if someone passes away and they're married, their spouse gets half and their kids get the other half. If you own a home and it's not in both your names, that can create an interesting situation depending on what your spouse's relationship is with your kids. This gets especially tricky with blended families and really confusing. So if you're talking with your spouse about this stuff, then I would say have a discussion about what I call level 1 protection, which is if one of you goes, does the other have access to everything, or does it go where you want to? You could do this. That's why in the presentation I talked about joint ownership or beneficiaries. So if everything is joint, or if your husband passes away and it automatically goes to you, and the strategy is let the kids figure it out, then you may be fine. You just want to make sure each of you have that list, you know where to find everything, and all accounts are either joint, or if it's not joint, then the other spouse is the beneficiary and the kids can figure it out. I'd still encourage you to look into powers of attorney in case incapacity ever becomes an issue, but that's really the best I got. In terms of getting jinxed, in my personal experience, I rarely see people come in for a plan and they get hit by a bus. But what with our joint ownership, how can you sign your parents' checks if they are incapacitated? So if you are a joint owner on an account, you can usually sign checks or access that account. If you're the way to be able to access that account if you're not a joint owner is with either a financial power of attorney, like I talked about before, or being listed as a signer, convener, or power of attorney. A lot of banks or financial institutions have their own forms for that. The lawyers use the what's called the statutory power of attorney for property. That's pretty much universally accepted and enforced. But you can go to the bank directly and ask to be a signer of convenience or a power of attorney, and they may have a custom form. Fees are always good. So the asking a lawyer to quote fees for estate planning is like asking a doctor to quote fees for a medical procedure before they've seen you. And this is endlessly frustrating for clients because they want to call and say, how much for a will? How much is for a trust? And unfortunately, I got to give you the lawyer answer. It depends. It depends on what you need, the complexity of it. And so even to give you a range, it's hard to even do that because every lawyer situation is different and every client situation is different. So the ranges you'll see, you can have on the inexpensive side, if you have a law firm that does wills and trusts and 20 other things, and they're throwing a bunch of cookie cutter documents at you that they're barely even reading, you could still be under $1,000 for a cookie cutter set of documents and that are hopefully signed correctly. And then on the other end of the spectrum, you have some operations where lawyers are pushing these trusts that are this thick that you only need if you got 8 million plus in assets. And, those can be 10 or 20 grand. And so what I would say is first, get legal advice on what you need. And a lot of lawyers, myself included, will do that for free. Well, so they would say, well, okay, here's what you need. Then if you like that lawyer and they quote you a reasonable price, you can decide to hire them. Or if at that point you're clear on what you need, then you can shop around if you want. So that's the best I can do on fees. Did you mention it might be better for a beneficiary rather than a joint owner on a bank account with your parents? Generally speaking, yes. If you are a joint owner on an account with your parents, they made an immediate gift to you. And depending on the amount, there could be tax issues with that. Plus, if you end up going through a divorce, get into a car accident, have to file, any of these weird things happen, you can inadvertently be subjecting creditors to mom or dad's account. So it's much better to be a power of attorney or a signer if they need you to write checks and then a beneficiary if they want it to go to you when they pass away, not a joint owner. Great, I'm glad that came through. If I pass before my wife and we have no children, what happens at her passing if no will is updated? Okay, this is an interesting question. So in Illinois, if you pass and you have no will and you have no children, everything goes to your spouse. If they then pass, they have no live, and assuming they're not remarried, they have no spouse. If they have no kids, then the next step is it automatically goes to any living parents. If there's no living parents, then we go to siblings, and then it goes out and out. And the Illinois plan goes on and on and on. It has a lot of backup plans before it goes to the states. Are trusts recommended for people of certain levels of assets? Yes. No. Okay. So trusts. If your total estate, so everything you have that goes anywhere when you're not around, is more than 4 million or likely to be more than 4 million, then, and you're a married couple, then each of you having a trust could potentially eliminate the estate tax. So generally speaking, from a taxation standpoint, absent all these what ifs or whatnot, if you're under 4 million, you don't need a trust for tax purposes. For more practical purposes, if you're under 4 million, then it depends on how specific you want to get with where things go and how many backup plans you want to have without going to court. What do I mean? Well, Illinois passed the Transfer and Death Instrument Act, where you can have real estate automatically go to people when you pass without going to probate and without having to pay a title company a bond, which can be up to 2 to 3% of the sale price. Yikes. Sometimes after a while, they can go down to 1%, but still, that's a big donation. So the transfer and death instrument automatically goes to those people. But if they're not around, then if it's done correctly, it can go to their kids. But then if you have a minor owning real estate, you got to go to court for them to be able to sign anything or have their guardian sign anything. So if people are worried about that or want to get more specific than the state's plan and not have to go to court, then a trust can be a useful tool. So hopefully that answers the question. So a trust a lot of times depends on how specific you want to be with things or how worried you are about the what ifs. Pros and cons of having a trust as the beneficiary of a retirement account, or better to have beneficiary listed on the account. Tax question. I'm going to dodge it a little bit because, and I'm probably going to get some flack for this, but in my experience, not all financial planners or accountants agree on this question. So I'm going to say it's a tax question. Go with the people that you or your family is likely to use for this advice. Some attorneys do both tax and estate work. But what I would say is, generally speaking, the most conservative approach is to leave retirement accounts out of trust. If your children are adults, they're likely to get financial advice and you don't need any of the protections of a trust. So a lot of people will say leave the retirement accounts out of the trust. Some argue the trust functions if it's designed correctly, like a conduit, so it just passes through, so it doesn't matter. Others say there's a 5-year rule. So there's a lot of nuances to that one. I would say, generally speaking, get some tax advice for your specific situation. When in doubt, leave it out. But make sure it's got a beneficiary, because if it doesn't, you're going to end up in probate court. Good question. Can you have more than one power of attorney? Yes. Well, kind of. I always recommend one person at a time. But I like a first, second, and third choice, or even a fourth if you have one. At a minimum, you need one. But I like having 2 other backups, because if someone's unavailable or unwilling, then you can still have someone step in without having to go to court for a guardianship. If you set up a trust while living in Illinois, but you relocated to another state, which law applies? Generally speaking, the laws of your estate will first be governed by your primary residence when you pass away. However, if you have property in a different state, it can get tricky. So if you create a trust in Illinois and put your house in your trust and you update all your beneficiaries, and then you sell the house and you move to another state, you could put that new house into the trust you created in Illinois, but the laws of trusts can be state specific. So at a minimum, I would recommend talking to a local estate planning attorney in that state to make sure that the trust will meet the requirements of an enforceable trust in that state. I had someone come in the other day with a trust from out of state, and I looked at it, and it was a solid basic trust, and it's all they needed, and it met all the Illinois requirements. And I was like, you know what? You're good. The power of attorneys weren't the same, didn't have the same signing requirements. So we updated those. The will wasn't quite Illinois compliant, but the trust was fine. So typical lawyer answer, it depends. Generally speaking, if you move to a different state and that's your primary residence, then at a minimum, I would meet with a local attorney and see if anything needs to be updated and if you can put things in the trust or the trust will be enforceable in that state. Generally speaking, trusts are state specific. Now, that being said, if you have real estate in multiple states, so you got that cabin up north in Wisconsin and you have an Illinois trust, then a lot of times what we'll do is we'll hire a Wisconsin licensed attorney to make sure that the house can go into the Illinois trust. And yes, you can have an Illinois trust and out-of-state properties in that trust. And most of the time it'll be fine if it's properly deeded in. Any other questions?
Well, if we don't have any other questions today, thank you so much, Adam. I think that question and answer was also super, super beneficial. So thank you all for being here today. Very, very important topic that we went over today, and we appreciate you being here and taking the time out of your day, Adam.
Thank you everyone for the opportunity. Wish everyone the best of luck, and we'll see you soon.